In the previous session, we have seen scores of developments in the recent past which have brought in this issue of judicial independence, and at the same time we have seen this issue of the suicide note of Calico Pool, which has clearly raised the issue of judicial accountability. Remember, as I told you, the judicial independence must always be seen in association with judicial accountability, because together these two give rise to the necessary functioning and institutional structure of judiciary as per the constitutional scheme. If you observe the statement given by Dr. B.R. Ambedkar on the floor of the Constituent Assembly during the Constitutional Assembly debates, he said, there can be no difference of opinion in the House that our judiciary must be both independent, and at the same time he says that it must also be competent in itself. And he says with continuation that the question is how these two objects can be secured. Remember, the independence of judiciary can be continuously ensured only when the judiciary is competent in itself. Otherwise, in the absence of such judicial competence, there will be unscrupulous intervention from not only the legislature but also from the executive. This is where he says that it can be independent only when it has sufficient judicial competence. If I have to tell you what in simple terms this independence of judiciary has to be understood as, then I must tell you that the independence of the institution of the judiciary and also independence of the judges put together leads to the formation of what is called as independent judiciary. I repeat, it is not only the independence of institution itself, it is also about independence of judges which form part of the judiciary. Remember, these two dimensions along with judicial accountability has been ensured under the constitutional scheme under various provisions. We know that it is Article 124 and Article 214 which set up the higher judiciary in India respectively by forming Supreme Court and High Court. However, if you observe Article 13, which defines what is called as law under the fundamental rights, which has implicitly brought out the power of judicial review for both High Court and Supreme Court, that is for the higher judiciary. The power of judicial review, which is implicit in Article 13, emanates from the fact that even though the laws are passed by the legislature and even though these laws are implemented by the executive, it is the organ which interprets this particular law in such a way that if it is violating or going against or ultraviolating the constitution, then it must be held invalid. And this function of holding it invalid lies with the institution of judiciary. Even though this is not directly mentioned under Article 13 as a fundamental right, this right now lies with judiciary. Hence, judicial review being part of Article 13, that is being part of fundamental rights straight away, it has given judiciary an utmost power. This judicial review hence is the one which leads to the situation where judiciary is acting as vanguard of entire constitution and vanguard of entire rule of law, which is the bedrock of any democracy. It is the judiciary hence which ensures the rule of law in any country. First point. Second point, along with this, we also know that under Article 32, judiciary is vested with what is called as writ jurisdiction. Here judiciary means all the higher judiciary. It includes Supreme Court and High Courts. This writ jurisdiction of the Supreme Court and High Court is giving them a necessary teeth in order to ensure that the executive tyranny is addressed effectively. And along with this, we know that under Article 50, which calls for separation of the executive from the judiciary, clearly tells us the fact that this judiciary must be held independent of the executive. Even if I look at all these three articles put together, they clearly form the basis for the judicial independence in India. But at the same time, here, even though judicial review as a power has been given under Article 13 and writ jurisdiction as a power has been given under Article 32, and Article 50 is calling for clearly the separation of the judiciary from the executive. Please remember that it doesn't mean that the judiciary is well above the constitution. It has to behave itself within the fold of the constitution, meaning constitution is itself acting as a bulwark against the supremacy of the judiciary that may come out because of these provisions. Fourthly, along with this, we know that there are various other aspects which have been mentioned under the constitution whereby the independence of the judiciary is ensured, and at the same time, given the fact that these are the same provisions which also ensure what is called as judicial accountability, we see the constitution with a nice blend of both independence, accountability together. How? Look at these aspects. The constitutional scheme gives us what is called as security of tenure. The constitutional scheme gives us what is called as qualifications, requirement of oath, the difficult removal procedure, and also the bar on the judges of the Supreme Court to plead or act in any court or before any authority within the territory of India. All these have been mentioned under Article 124 for Supreme Court and Article 217 for High Court. Given the fact that along with 218, 219, 220 read in association with 217, security of tenure, qualifications, requirement of oath, the difficult removal procedure, and the bar on the judges of the High Court to plead or act in any court or before any authority within the territory of India except as judge of the Supreme Court. Both these provisions, Article 124 and the collection of these articles for the high courts of various states, they give you the fact that independence of this judiciary is ensured from the arbitrariness of the legislature, and tyranny of the executive, such that in all these aspects which are important for the impartial and independent function of the institution, there is no intervention from these two organs of the state. Given this fact, even though we know that legislature, executive and judiciary which have been separated with the implementation of principle of separation of powers, remember, this principle of separation of powers is furthered by providing these institutions the space within which they have to function independent of each other without much intervention from one of the organs of the state into the affairs of other organs of the state. For this to occur, primarily it is these aspects of the institutional structure which must be ensured the constitutional protection. The security of tenure, qualifications, requirement of oath, the difficult removal procedure, and the bar on the judge of the Supreme Court or High Court to plead or act in any court or before any authority within the territory of India except as the Supreme Court judge are all such provisions which provide these independence. And at the same time, remember, when the security of tenure has been provided, it means that he has to ensure within this tenure independent functioning, but not only the independent functioning but also impartial functioning, while ensuring the strict implementation of power of judicial review and the writ jurisdiction which has been given under Article 32, along with various jurisdictions which have been given from Article 131 as original jurisdiction, etc. and etc., such that the rule of law and the constitutionalism is upheld in the country. And along with this, the requirement of qualifications, requirement of taking an oath, and also the difficult removal procedure are also meant to ensure this accountability of the judges. Qualifications, when are looked at, they are looked at because they have to be accountable to these qualifications. Number two, the requirement of oath is to ensure that even through the constitutional scheme, we are ensuring a moral bar on the judges. So all these put together, they are not only ensuring judicial independence, but they are also meant to ensure judicial accountability. And along with this, we also have the fact that there is a bar on the discussion over conduct of any judge on the floor of the House, as has been given under Article 121 for Supreme Court and Article 211 for High Court as protection respectively. This is also to ensure that the judicial independence is ensured from the clutches of legislature. Along with this, we also know that the salaries and allowances to be charged upon the Consolidated Fund of India, whatever that will be provided for the judges of the Supreme Court, and hence they will not be subject to what? Oath. Whenever the expenditure is charged upon the Consolidated Fund of India by the executive, then that will not be subjected to oath, and hence this provision that the emoluments which shall not be reduced to the disadvantage of any judge under Article 125 and Article 221 respectively for both judges of the Supreme Court and High Court, except during the proclamation of financial emergency under Article 360, also meant to ensure, all these are meant to ensure the independent functioning of the judiciary, given the fact that their salaries will not be subjected to any kind of debate and any kind of reduction given the disadvantage of one or the other particular judge owing to certain situations. Along with this, there is one more extra protection which has been given under the Constitution. Whatever the administrative expenses of the Supreme Court, the salaries and allowances etc. of the staff of the Supreme Court shall also be charged upon the Consolidated Fund of India under Article 146. That means the same protection has been extended further. Similarly, we also know that there is power to punish for contempt of court under Article 129 and Article 215 for both Supreme Court and High Court respectively. Also, to protect the judiciary from the dangers within, the control over subordinate judiciary is also vested in the respective high courts under Article 235. See, given the scores of provisions given under the constitutional scheme, we know that they are meant to ensure independence of the judiciary, number one. Number two, they are also meant to ensure the competence of the judges, because once you look at the qualifications of the judges, once you look at the difficult removal procedure that has been ensured, and also once you look at the provisions such as their salaries must be charged upon the Consolidated Fund of India, and also the power to punish for contempt under Article 129 or Article 215, we observe that they are also meant to ensure sufficient competence in the judge of the Supreme Court without having any ill will or favor towards any person, such that there is complete impartiality on the part of functioning of an individual judge, and also the put together it is the need for the impartial functioning of the entire institution. This is how various constitutional provisions under the Constitution try to ensure the independence of judiciary and also to an extent accountability too through these same provisions. In 1973, we observe the Supreme Court in the Keshavananda Bharati case held that independence of judiciary is part of basic structure of the Constitution. Remember, it is this judgment which has laid the foundation for what is called as the judicial activism, and this judicial activism went on to ensure that there are various judgments which are given against the functioning of both legislature and executive in such a way that this independence of judiciary has ensured continuously. Remember, as I told you, independence of judiciary has its basis in the doctrine of separation of powers, as we have seen earlier at the start of the session. So, the functioning of judiciary is to ensure that the fundamental rights and ideals of the Constitution are protected against the arbitrariness of the legislature and tyranniness of the executive in such a way that this complete separation of powers, even though has not been implemented in India through the constitutional scheme which is called as strict separation of powers principle, even under the parliamentary functioning of Indian democracy, this particular aspect of rule of law, by ensuring these basic fundamental rights and basic ideals of the Constitution which need to be implemented for the clear implementation of thorough implementation of constitutional scheme in India, and also to ensure constitutionalism, are necessary in such a way that independence of judiciary will lead to such a consequence. Hence, the independence of judiciary is a necessary concomitant of the power of judicial review under a democratic constitution, as essential for its functioning as the watchdog under the constitution. However, like every organ of the state and even public functionary in a democracy, the judiciary as an institution and every judge as a public functionary is accountable to the political sovereign. Who are the political sovereign? Political sovereign is the people. So the only difference is in the form or nature of the mechanism needed to enforce their accountability, because in our parliamentary democracy, judiciary is selected, which is an oligarchic institution but not a democratic institution, but not, that means they are not elected, unlike the other two organs of the state which have election as a process for their accountability towards the political sovereign. In short, judicial accountability is hence must also be a facet of independence of judiciary, for which we find that many are fighting for, because of the recent developments that we have seen in the earlier session. And this particular mechanism to enforce judicial accountability must also preserve the independence of the judiciary. That means both must go hand in hand. As pronounced by Dicey, rule of law is the bedrock of any democracy. It will be adversely affected if the independence of the judiciary is compromised by the erosion of the integrity of the judiciary. Such erosion can be from within as well as from without. This is what the Calico Pulse letter was clearly revealing to us. In spite of the understanding that it might be a falsified statement that was issued by Kalsikopul through the suicide note, remember the fact that the way that has been dealt with, the way it has been converted into a criminal writ petition, it tells us clearly that the action was going against the necessary constitutional propriety that was decided in this Veeraswamy case. Given this development, hence, safeguards to protect the judicial independence in our constitution must also lead to ensuring the judicial accountability to the political sovereign. You know that as we have certain provisions as safeguards to protect the judicial independence in our constitution, there are several international instruments which can also be read into the constitutional guarantees by virtue of whatever the canons of construction that were evolved in the Vishaka case in 1997. Remember, this Vishaka case was pertaining to a particular gang rape against a social worker for stopping a child marriage by Gujars in Rajasthan in 1992. This harped on international conventions and norms, which is significant for the purpose of interpretation of the guarantee of gender equality, right to work with human dignity under Articles 14, 15, 19 and 21, because 19(1)G clearly enunciates the right to work with freedom, of course with certain reasonable restrictions. And also these international conventions had the safeguards against the sexual harassment implicit therein within these articles. So the court felt gender equality includes protection from sexual harassment and a right to work with dignity. These are the two basic rights which have been violated when the social worker was carrying on her social work, number one. Number two, when she was stopping a child marriage by Gujars. So this entire episode had these two issues of protection from sexual harassment and right to work with dignity. Both have been seen as various dimensions of gender equality. This is what the universally recognized basic human right is, which has been understood by interpreting these international conventions and norms. That means the common minimum requirements of this right have received the global importance. So the aspect of judicial independence too must require such an understanding, and this aspect of judicial accountability along with judicial independence must also require such an understanding. So the international conventions and norms are of great significance in the formulation of guidelines to achieve the right to work with lot of dignity. The same understanding can also be extended to what is called as judicial independence put together with judicial accountability. So the obligation of the Supreme Court on Article 32 of the Constitution for the enforcement of many fundamental rights in the absence of legislation must be viewed along with the role of judiciary envisaged in the Beijing Statement of Principles. Beijing Statement of Principles, which were accepted in this particular Asian region. These principles were accepted by the Chief Justices of the Asia and Pacific in Beijing in 1995 as those representing the minimum standards necessary to be observed in order to maintain the independence and effective functioning of the judiciary. So the principle of independence of the judiciary has been laid down in various human rights instruments, including the UN Declaration of Human Rights. If you look at Article 10 of this UN Declaration of the Human Rights, it clearly talks about the need for independence of the judiciary in order to ensure all these safeguards and rights which have been enunciated under this Basic Human Rights Convention. Number 2, if you look at the International Covenant on Civil and Political Rights, it also talks about the need for independence of judiciary. There are also a number of UN standards, in particular the Basic Principles on Independence of Judiciary as endorsed by the UN General Assembly in 1985 is also very important principles. Along with this, the Bangalore Principles of Judicial Conduct that has been accepted in 2002 is also a very significant international convention. Apart from this, within the European framework, we have the right to an independent and impartial tribunal that has been guaranteed by the European Convention on Human Rights, ECHR. Of course, if you look at what is called as the Copenhagen document, the Moscow document, the Istanbul document, etc., also talk about the commitments towards the independence of judiciary, and which has been specified in what is called as Brussels Declaration on Criminal Justice Systems, and this has provided again the independence of judiciary as the necessary facet for such a convention to be implemented. Along with this, we have what is called as key recommendations on judicial independence in Eastern Europe and also South Caucasus and also Central Asia, which were elaborated against the background of the much needed international standards. In addition to these, UDHR and ICCPR, UN has set forth a set of standards which came to be known as Basic Principles on Independence of Judiciary, as I was mentioning earlier. The Beijing Principles on the Independence of Judiciary, which has been adopted in 1997 in Manila by the Chief Justice of the Asia Pacific region, and the Bangalore Principles of Judicial Conduct adopted in 2002 are two such documents which needed particular mention with respect to this judicial independence. The essential values which have been stated in the Bangalore Principles are worth mentioning. What are those values which have been mentioned? Number 1, it's a prerequisite to the rule of law. It is a prerequisite to the rule of law. Secondly, it must include what is called as integrity. Thirdly, it must include impartiality. Fourthly, it must also have both individual independence and also institutional independence as part of judicial independence. Fifth, it must also have the necessary constitutional propriety. And sixth, it must also have appearance of propriety as part of the constitutional propriety when these judges are acting as part of their necessary judicial interpretations. Along with this, equality of treatment of all is also part of the necessary judicial independence. Along with this, competence and diligence have been seen as necessary dimensions of this independence of judiciary. So it concludes with the need of effective measures to be adopted to provide mechanisms to implement these principles. So it's all about these necessary mechanisms which have to be ensured such that these principles are implemented without any violation. If you observe, all these principles that we are looking at are much abstract in their nature. So how to bring these principles into the practice? Here you must remember that the necessity of judicial independence and judicial accountability and their implementation in practice primarily lies in the opposite scrutiny of processes that we have under the constitutional scheme. For any institution such as judiciary and or any other such independent institution that we have under the constitutional scheme, three aspects are primarily important. These are processes of appointment, then you have the processes of transfer and removal, which is particularly subjected to the High Court judges with respect to transfer and removal for all the judges from the higher judiciary, and also the post-retirement employment. The post-retirement employment, as we have seen in the case of Chief Justice of India Ranjan Gogoi's case in the government appointed positions. So in brief, what we are trying to convey is, in order to implement mechanisms which are crucial for implementing these principles as part of the need for effective measures to ensure judicial independence, remember these three processes are of utmost importance, and their opposite scrutiny gives us what are the reforms which have to be implemented in such a way that judiciary ensures independence and her accountability together at the same time. If you observe, the appointment of the judges is related to the issue of what is called as pre-tenure, and whatever the transfer and the removal procedure that we are referring to is all about the issue of in tenure. And if you look at the issue of post-retirement employment, it relates to what is called as post-tenure. So post-tenure issues, in-tenure issues and the pre-tenure issues or processes gives us the understanding of what sort of mechanisms that we have and how these have to be improved in such a way that both of these principles necessary for the concomitant implementation of judicial scheme under the constitution is required. So this has to be done because a biased perception or opinion has been presented either towards or against these particular fundamental premises on which the judiciary must be built. I repeat, this entire opposite scrutiny of these three important processes must be done because a biased perception has been presented either towards or against these fundamental premises on which the judiciary must be built. For that matter, any independent institution under the constitutional scheme must be built. As H.M. Sirvai, the noted constitutional expert, has stated, following a history of executive interference in judicial appointments and transfers, a reactionary conception of judicial independence has been championed by the Supreme Court, and because of this particular opinion of the Supreme Court or biased perception of the Supreme Court, probably it has institutionalized this particular cause of judicial independence as a constitutional doctrine, as we have seen in the case of Keshavananda Bharati case in 1973. That means this particular series of judgments since this case of Keshavananda Bharati case saw the judiciary itself to the exclusion of, remember, the other two coordinate organs. They are not the subordinate organs, they are the coordinate organs of the government which have to be treated on equal footing with the judiciary as indispensable to the protection of its own independence. I repeat, since the delivery of Keshavananda Bharati judgment, there were series of judgments issued by the Supreme Court or the higher judiciary, which saw that the judiciary itself, to the exclusion of the other coordinate organs of the governments, as the indispensable requirement to the protection of its own independence. Hence, the various mechanisms of or underlying rationales for the appointment of judges, transfer of judges between the high courts, removal of judges, and the post-retirement employment of judges in the government appointed positions must always be in the hands of the judiciary, as they have understood. So the need to analyze the justifiability of such processes and the views underlying them in terms of judicial independence and accountability is what we are going to do in our next session. So looking at these two dimensions from the point of view of in-tenure processes, pre-tenure processes and post-tenure processes, leads to the necessary conclusion in terms of what are the reforms which are required towards the present constitutional scheme in such a way that these two principles are achieved to restore not only the confidence of the public into the institutions that we have under the constitutional scheme, but also to ensure constitutionalism without fail.